Gentlemen, and welcome to this afternoon's webinar convened by the British Chamber of Commerce, Thailand. My name is Stephen Frost. I'm chair of the British Chamber's Legal and Taxation Committee. I'm very pleased to welcome our distinguished speaker this afternoon, Kun Wasantachai Watanawong Wisut. Kun Wasantachai has over 32 years of experience in practicing commercial laws. His practice areas focus on labour litigation in particular. He gives advice related to Thai labour law in various industries. He is also experienced in litigation in various matters in court, as well as arbitration cases in Thailand. His experience also includes preparing, drafting, and negotiating employment contracts and termination agreements. His current position is as a litigation partner of ILCT, that's International Legal Counsellors Thailand, a very long established and distinguished independent Thai law firm. He is also a member of the Lawyers' Council of Thailand. He holds the following professional qualifications. First of all, a Bachelor of Law degree from Ramkhamhaeng University, a diploma in business shipping from Chulalongkorn University, a master's degree in business law from Thammasat University, a diploma in American business law from Michigan University in the USA, a second Bachelor of Law degree from Thammasat University, and a graduate diploma in business law from Thammasat University. We'll start the presentation now, and if you wish to put any questions to the speaker, can you put those up in writing, and we will do that at the conclusion of his presentation. So welcome very much, a big warm welcome to Kun Wasantachai, our distinguished speaker this afternoon. Thank you.
Thank you, Stephen. Good afternoon, all attendees. Yeah, it is my honor to be a guest speaker once again here for BCCT today. Okay, I hope that you will enjoy the presentation. Okay, I will start presentation now. Okay, I will follow what the issues mentioned by BCCT today. So I will follow the issues on that slide first. Okay, the first one is the issue that whether temporary or permanent closure of business for economic during this period of time. So the question is, can an employer close its business temporarily or permanently during COVID-19 pandemic due to economic reason? So according to the economic reasons, the business may be closed. Of course, it's sometimes necessary. The labor law involves that whether this can be done. So this is the questions. Okay. The answer is that the employment contract still exists. The employment contract still exists. So employees can claim from the contract, and the employee is entitled to get paid of his salary in full during COVID-19. During COVID-19. Okay, this is the according to the contract. Now we come to legislation. The legislation on this is that section 54, 55, and 70. They said about the wages, salary, and the contract. that is still existing. So the duties of the employer employees will be like this. Section 45, wages or salary must be paid in Thai currency. Okay. Section 55, wages or salary must be made at the workplace or as agreed in the contract. The contract still exists. And Section 70, an employer has its obligation to pay wages or salary, overtime pay, holiday pay, accurately and punctually, timely, on monthly basis. So that means no way you have to pay. The employer have to pay anyway, even though the pandemic, during the pandemic, no, the business is closed, something like that. So if it is default, if employer didn't pay and employer is in default of payment, if it is in default of payment, whether for wages, overtime pay, payment for work on holidays, this could cause the employer liable for interest. Section 9 saying about interest, that failing to do its obligation to pay wages. This is the obligation of the employer. The employer shall be liable for interest at the rate of 7.5% per annum. So cannot do anything. However, the employer has an alternative to negotiate with the employees. This is the way out. So the business is closed, no business. How the employer pay? So this is the way out. The employer has an alternative to negotiate with employees and request to reduce wages in the situation of pandemic of COVID. So negotiation is necessary. And if negotiation is successful, the employer should get, this is important. If negotiation success achieved, the employer must get written consent from employees on such reduction of wages. Must get this consent. Otherwise there will be a dispute or challenge later. Must get consent on this. So up to negotiation. Okay. The legislation on this is Section 77 of the Labor Protection Act, 1998, provided as follows. Whereas an employer is required to obtain consent of employee or make an agreement with an employee concerning payments under Section 54, 55, 70, and 26. This the legislation I already mentioned. Okay. Legislation 77 provides that the employer shall arrange for consent. Okay, next slide, please. For consent. Written consent to be signed by employee or an agreement to be expressly made in particular. So after negotiation, after achieved, so the consent must be made in writing. So this is according to Section 77. So based on the above legislation, the request for wages reduction is the way out during the pandemic of COVID. But it must be made in writing. The consent must be given by employee. So this is the way out under Thai labor law. Okay, we come to another questions. Wage cuts Can an employer reduce wages for a short period or permanently or postpone its obligation to pay wages? The same is Act Section 76. There is legislation on Section 76 that it is prohibited under Thai labor law to deduct wages when payment required to be made on monthly basis. Section 76 said that you cannot deduct wages from monthly paid on salary monthly paid basis. When the payday comes, employer have to pay salary. The Section 76 said that can be deducted. The employer can deduct wages only for tax, for cooperative, under the cooperative law. If you have a cooperative in your business, your factory. And number 5, for the contribution of the labor union. Number 4, for negligence act made against employer. Only that, only 4 things. Otherwise, you cannot deduct wages. So, come back again to 77. If you would like to deduct wages, you have to come to Section 77. So you have to negotiate with employees and get consent for wages reduction. So whatever, you won't pay anything, you want to reduce wages, postpone wages, you have to get consent anyway. Okay, this is the way out. Under Thai labor law, you cannot do anything. Okay, now we come to the second issues. Transferring an employee to another location. Under Thai labor law, there are several Supreme Court precedents that rule that the to transfer employee to another location. But this is not actually the law. It is the Supreme Court precedent. The Supreme Court precedent said that the employer is entitled to move employees to work in another place. But this must be for serve the purpose of the employer. So the employers will be entitled to do this when there is expressly specifying this entitlement in the contract. So it should be specified clearly in the employment contract that the employer is entitled to move employee to work in another location under the appropriate situation for the business purpose, for beneficial of the company. You must put this clause in the employment contract initially. Like this. Okay, next slide, please. For example, you should put like this. The employer shall have its discretion. You put it discretion and the right to transfer employee to another location to work in the atmosphere which is deemed suitable or appropriate for such work and for benefits of the company. If you have this clause, so that means you serve the employer's right to move under the discretion and for the purpose of the business. So you can do this. If you don't have this clause in the contract, it will be a challenge that the employer is trying to do something that we call change conditions of work or working condition. So I will talk about this again. So the condition of work cannot be changed in inferior manner. It must be changed for beneficial to the employees only. For example, if you come back to the first issue, you reduce wages, it's not beneficial to employee. So you cannot reduce wages, postpone payment, cannot do anything. So this is conditions of work cannot change. Transfer to work to another corporation is the issues for changing condition of work. Reduce the wages, reduce wages is also conditions of change condition of work as well. Okay, so it is a suggestion that you should put this clause for transferring the employment, if you wish, if the employer wish to do so, should have this clause in contract. This is the way out. Okay, Stephen, another next slide, please. Okay, so as I said that this is the conditions of work or working conditions. There is a Section 20 of the Labor Relations Act elaborate to effect that employer cannot change condition of work or working condition into inferior manner. This is the law. So reduce wages, inferior. Increase, okay, superior, you can do. Move to another. Work here in Bangkok, you move to Ayutthaya, move to Phuket, move to. It's not beneficial. They have to change place of work, far from family, so it's not beneficial to employees. So inferior, so cannot do. Okay. This is Section 20 of Labor Relations Act. Okay. So we can summarize. The summary on this is that the change on condition of work or working condition must be made in the manner as it is more favorable or it is more beneficial to the employee, unless the way out again, unless you get written consent or you negotiate with employees and they give you the consent that, okay, for example, employees understand that during the pandemic of COVID, the business is closed, no money to pay, and they don't have to do the work, or maybe they stay at home without pay, if they agree. If they don't agree, they can go to the labor official and claim for wages in full plus interest. That's we have to negotiate. Okay, we come to the change on conditions of work in a manner that is more favorable to the employee. Would be something like this. If you raise wages, okay, beneficial to employee. You provide more uniform, not reduce. If you reduce uniform, so it's not more favorable. It's not more beneficial. Provide car allowance, provide quarantine bonus, provide house rental fee, provide car rental fee. So this you give more. It's beneficial to employee. So no problem. They would agree, no problem. But if you reduce, postpone, so something like that, the change on condition of work in inferior manner would be wages reduction. You ask for reduction of the wages downgrade the position. So this cannot be done. You have to get consent. Otherwise, there is a challenge. And they can go to the labor officer. Now we come to the third issue. Temporary closing down of the business due to government order. So this is based on the government order. We say that it is lockdown. If there is lockdown in the first wave, the second wave in Thailand. For Thailand, we have this first one, and first and second lockdown. Now we come to the third wave. For this is many people ask during the temporary closing down the business by the government order. So can the employer reduce wages, or can the employer request for the rule of no work, no pay, something like that? So there is a rule. Section 75 is the legislation on this. In the case an employer finds that it's necessary by an important reason which affects his business operation to an extent that he is unable to operate his business normally, and which is not force majeure, and must suspend his business either in whole or in part or a temporary period. The employer shall pay wages to his employees at not less than 70% of wages on work day that the employees receive prior to the employer's suspension of his business operation. Throughout the period, the employer discontinues the service of the employees at the place of payment under Section 55 and within the period of payment under Section 70 plus 1. The employer is required to notify in writing to the employees and the labor inspector at least 3 working days in advance before the closure of its operation under the first paragraph. So this is the section that allows to pay 75%. But it must not be force majeure. So there is the interpretation of the law, of the lawyers on this. When COVID spread out in Thailand, someone said that we can use this, and someone said we can use this section. So what actually is the reason? COVID-19 situation can apply to Section 75 or not. Section 75 states that it must not be force majeure. But COVID-19 is force majeure. Force majeure. So there is interpretation, and someone said that hey, employer cannot pay 25%. Someone said, yeah, we apply 25 simultaneously in indirectly, something like that. So to avoid this interpretation, the government by the Social Security Office issue the ministerial regulations to amend Section 79 of the Social Security Act, being 79/1 of this act, to the effect that, so you don't have to argue whether Section 75 can be applied for payment for 75% or not. So they issue another rules that they put the measurement on the Social Security Act that they reduce the contribution of the Social Security Fund employer from 5% to 4%. employee 5 to 1. This is the measurement. And for the non-employment due to COVID-19 and the business is closed, whether by law, by order, or by whatever, by state quarantine 14 days. So they will get paid from the employment. For the government. Yes. Okay. Next slide, please. Yeah. And there is 2 issues. Whether the employer would terminate employees or not during COVID. If termination is made, so according to the new rules issued by the Social Security Office, the employee will be entitled to wages at daily rate wage at 62% from the Social Security Office for a period of 90 days, March, April, May. So that is the second wave. Now we will come to the third wave. If termination is made, employee will be entitled to wages at the daily rate wage at 70% from Social Security Office for a period of not exceeding 200 days. Only 200 days. Okay. Next. If resignation, if the employees resignation by themselves, so the employees will be entitled to wages at daily rate wage at 25% from the Social Security Fund for a period not exceeding 90 days. Upon application, is filed with the Social Security Office. So the employee have to apply to get this amount. So this is the section 79, which is issue from the Social Security as a new measurement. So you can say that it just like amend the section 29 to 7. This is the second wave already used this. Now we come to the third wave. Okay, next slide, please. Okay. Oh, for the SME entrepreneur, freelance, agriculturist, or farmer, for those who are not under the scope of Social Security Act, for the freelance, something like that, they will get 500 baht for a period of 3 months. For the second wave. The employer has to apply the request for Social Security Office to get this amount. Okay. Now we come to the third wave. Next slide, please. This is the third wave. The third wave, Mr. Nantachai, the spokesman of the Social Security Office, pronounced on 15 July that the employees under Section 33 of the Social Security Act and the business owner in the zone of 10 provinces. The third wave now, we closed down only on some. The second wave, we closed all Bangkok, or Thailand. But the third wave, we closed only some provinces. The red zone, we call the red zone, the green zone, the yellow zone, something like that. So only 10 provinces will be compensated, not all. Employees who are working under Section 30 of Social Security Act shall be compensated in some 2,000 up to 205,000 per person for 1 month, only for 1 month, when application is applied with the office. That's for the employees. For the employer, in red zone, in 10 provinces, Bangkok, Nakhon Pathom, Pathum Thani, Samut Prakan, Samut Sakhon, Samut Songkhlam, Pattani, Yala, Narathiwat, Songkhla, 10 provinces. Those visits were subject to government order to close its business. So it shall be compensated in the sum of 3,000 per person, whereas its business must have its employees not exceeding 200 persons. And the maximum amount of compensation shall not exceed 600,000 baht. So some business got this. So it depends on the number, but the limitation is 200 person, 200 employee. In your factory, in your company, you must have not exceeding, they will pay not exceeding to 100% and not exceed 60,000, only in 10 provinces. This is the measurement for to get compensation from government. The business in red zone area of 10 provinces must be closed down under the government order. They are the business of construction, hotel, food, spa, haircut, saloon, fitness center, etc. And this time, the third wave, there are curfew in 10 provinces during 9 p.m. to 4 a.m. So today, you cannot leave. You have to get back home early. Okay. Number 5, there are restrictions of movement and traveling across the provinces. People in red zone and in 10 provinces are not allowed to travel to another provinces or move out of its red zone area unless you have the permission. You must get, if you move to another location in red zone or move out, you have to get permission. You have to ask from the governor that you have business, you have to move, you have to something like that and get permission. Otherwise, the police will arrest you. Okay, now we come to issue 4. I think I'm going to keep the time. Section 4, suspension of work and termination. Next slide, please. Suspension of work. This is the provision of law regarding suspension of work. If the employer would like to suspend employees from work, there must be the charge that the employer is thinking that the employee is committing an offense against employer. So the employer would like to investigate them. So suspension for work, suspension of work will be start from thinking that there is an offense. Example, embezzlement, forged documents, whatever. And then you have to suspend work. Anyway, the employer can suspend work when there is the stipulation of the work rules. That means the employer have to check with the work rules whether there is this clause mentioned in the work rules or not. If there is no mention, you cannot suspend work. Employer is entitled to suspend the work to investigate employees who commit offense against employer, something like that. You must have this clause in the work rules. Then you can suspend. Suspend must not exceed more than 7 days. The law said that you cannot suspend for more than 7 days. So after 7 days, they will be entitled to come back to work. So you have to complete your investigation within 7 days. This is under law. Yeah. Okay, next slide, please. So we can summarize section 116 for suspension of work. That there must be the event that the first one, employer has alleged that the employer has alleged that employee has committed an offense against employer. Okay, this one. The work rule specify that the employer is entitled to suspend the work. Number 3, suspension must be made for investigation only. Suspension for investigation. Number 4, suspension can be made for only 7 days. The employee shall be informed of suspension and the alleged of commission of such offense. So you have to tell them why they are under suspension of work, what offense they are charging. Okay. Next slide, please. Okay. Based on the legislation of Section 116, if an employer would like to conduct measurement of suspension, employer has to review its work rule. If you don't have the work rules to suspend, you have to put it, you amend it, and so it is required to amend that the employer have the entitled to suspend work. Otherwise, you cannot suspend the work. Okay, you can amend if you would like to. Now we come to another issue: termination. Termination or dismissal of employment under Thai law. This is a very important thing. A lot of work. I have a lot of work on this issue, and this issue bring an action to the court very often. Yeah. So when you terminate employee, you have to think about this. Section 119. This is important. Section 119 of the Labor Protection Act. Okay. The law said that an employer may not pay severance pay to employee when employment is terminated upon the following conditions. The first one, performing his or her duty dishonestly. Perform dishonestly thing. So it's like something that trying to commit criminal offense, but it is not achieved. It is not success. In terms of law, we call the acting as attempt to commit offense. Attempt, but it's not attempt. The offense of attempt to commit criminal offense, but it is not achieved. Yeah. Perform this honestly, and the other one, commit this number one. We still at number one. Commit criminal offense, for example, forge document, embezzlement, theft, steal something from employer. Okay, you can terminate without severance pay. Second one, willfully cause damage to the employer. Willfully cause damage. According to the Supreme Court judgment, normally is about the labor union. When they have crunch with employer, they destroy something, they break the machine, something like that. This willfully cause damage to the employer. Or number 3, negligently act, cause serious damage. Negligent, do something negligent, drive the car with negligently, cause the company's car crash, something like that. Negligent. Okay, next slide, please. 4, violate work rules, regulation order which is lawful and just, and after written warning have been given by employer, except serious case. Okay, that's mean, according to this, the employee have to break your work rules 2 times, and there must be written warning at least 1 time. That means in the first violation, you must give warning letter. And then the employee do that again, second time, then you can terminate. It must be the same violation. The same violation of the thing. If they drunk, you want they drunk 2 times, you can terminate without severance pay. Something like that. Okay. Absent from work 3 consecutive days. So absent from work, they won't come to work without medical certificate. 3 days, 4 days, 5 days, you can terminate without certificate, medical certificate. Number 6, being sentenced to imprisonment. For example, the employees kill someone and they got sentenced to imprisonment, you can terminate. This is the cost that legal cost that employer may terminate without severance pay. Okay. 6 causes. If you terminate without such cause, for example, terminate because no business, the business is closing down by the government order, by the reason of COVID-19, the business at loss, running at loss, the business cannot tolerate to the COVID pandemic. So we have to make cost reduction plan, a plan for survival of its business, whatever. This is not what specified under section 119. Of course not. So you have to make severance pay. If you terminate without legal cost under section 119, you have to make severance pay. Anyway, no way out. So these are especially not legal causes under section 119. So if you terminate without section 119, you have to make severance pay. That's it. This is Thai labor law. So you cannot terminate without economic reasons. Without. I would say this, that you may question, hey, it's not fair. The business cannot run. Can we pay severance? Something like that. Actually, I would say that the labor court comply with section 119 about 90%. What is the remaining 10%? Yeah, you may say that remaining percent is another reason. It can be loss. Hey, what I said that, hey, you can say you cost deduction cannot apply, but 10% for this, the court may say that it is not need to make severance pay if the company get loss for 5 years, 5 consecutive years. This is from my experience. I made a case and they come to the Supreme Court judgment. Yeah. In the crisis of Tom Yam Goong, you know, Tom Yam Goong, hamburger crisis. Many business in the world got ruined and bankrupt. Although the big three of the aviation airways system, yeah, they terminate about 50,000, 10,000, something like that, 10,000 employees around the world, something like that. So the Supreme Court said that it is the world crisis, Tom Yam Goong. So it is not required to make severance pay. That is exception. You have to prove that get lost 5 consecutive years. Okay. Now, this is severance pay. We according to Stephen, I will go very quickly on this. Section 119 said that the severance pay must be paid according to service of years. if you work for at least 120 days up to 1 year, you get severance pay 30 days. Okay. Number 2, if employee work 1 year, less than 3 years, you get 90 days of severance pay. If employee, number 3, if employee works continuously 3 years, less than 6 years, you get 180 days. Number 4, you work 6 years, less than 10 years, you get 240 days for severance pay. If you work for 10 years, less than 20 years, you got 300. You will get 300 days for severance pay. And the last one, 6. You work, employees who work more than 20 years outward, so you got 400 days for severance, 400 days. So there are 6 range. So you will see this easier like this: 30 days, 90 days, 180 days, 1 month, 3 months, 4 months, 6 months, 300 days, 10 months, 13 months, something, 400 days assurance. Okay. So it should be noted that apart from severance pay, there is the other issue that normally the employer won't know. It could be interpreted as unfair termination under section 49. Section 49. This is different from labor law from other countries. Section 49 says something about unfair termination, but it rests to the court discretion. The labor court is entitled to determine whether it is unfair or not. So how can we know unfair or not? Normally, according to the Supreme Court precedent, they will follow section 119. If termination is not made under section 119, 90% the court would say that unfair. Because the court said that you have to make severance pay. So it is unfair, something like that. But if you terminate with legal cause, you do not have to make severance pay. The court may say it's fair, something like that. So try to terminate under section 119. Okay. So this is section 49, unfair termination. Okay. Next slide, please. Can an employee force working from home or garden leave? Garden leave. Okay. Now, next slide, please. So the leave under Thai law, there are only 6 categories of leave. 6 leave: maternity leave, personal leave, leave for military service, leave for sterilization, and leave for training or development of the employee's knowledge and skills. Only 6. You don't say garden leave. So what is gardening leave? Gardening leave. So it would be entitled to, apart from the 6 leaves, there are an annual leave. But annual leave is another thing. Annual leave is the entitlement for employees who work for a completion of 1 full year. Employee who complete their work 1 full year, then they will be entitled to annual leave. Under the law, annual leave allow for 6 working days. But it depends. The employer can make it more. Depends. This is the minimum standard, 6 working days. If you provide 6 working days, enough, that's enough. But the law allow for 60 days. Okay. But you have gardening leave, you have other, so what are they? They are part of business. Personal leave. Personal leave. So you may put in another leave in your work rules like this. Audience leave, marriage leave, gardening leave, education leave, leave without pay, work from home leave, funeral leave, whatever. This is personal leave. This is the personal leave. So you can make it. Such kind of leave could be interpreted as personal leave. Thus, it would depend on employer whether the employer would wish to apply more categories of leave in your company or not. If so, then it is advised that you can make it, put it in your work rules, put it more. You allow for this leave, marriage leave, funeral leave for how many days or something. Marriage leave, 2 days, 1 day, something like that. Up to you. So this is what the law says. It's up to work rules. You can set your own on your own. The employer can set on your own. So the question, another question, can employer enforce working from home? Finally, so as I said, that it is the employer's discretion on case-by-case basis. So you put it in your work rules if you would like to have this. If you don't have it, then it is discretion. Depends on the case-by-case. Is employer, can an employer enforce home gardening leave? So this is discretion. If you don't have it in your work rules, so it is the employer's discretion to force working from home. If you say that for the safety from COVID-19, you ask that whether it's appropriate, you can force, whether the employer can force employee work. So for the purpose of safety, you may say that. So it's up to discretion. The law didn't mention about this. So it's up to you. But if you force them to work from home, but you can do this. But if you didn't pay wages, or reduce wages or make wages reduction, so that's the problem. You come back to the first issue. You have to get consent. Garden leave, no problem. But cost or wages reduction, you must get consent. Okay, so gardening leave, force them to make garden leave, no problem. But you have to pay anyway. You have to pay. Okay, yeah, okay. Next slide, please. So, as I said, is this discretion whether to allow for such leave or not? Discretion, no problem. But if you didn't pay and during the gardening leave, it could be a problem. You must get consent according to section 77, as earlier discussed. Okay, that's all. Okay, I think we finish. And if we next slide, we have next slide.
Can we move to the questions, please?
Yes. Yes, please.
Question here from Kun Pornpot. The question is, if the contract is an outsourced working contract, that is,
Yes.
it's not a contract of employment, and the workplace is temporarily closed by government order, is the hirer still liable to pay wages during the closure period? So it's
Yes.
not a contract of employment.
Yes, they are still need to pay.
Okay.
The contract still exists. The outsourced employee is entitled to claim that the contract still exists, so they would get paid. They can claim that.
Okay, thank you. The next question is from Michael Wolf. His question is about daily paid workers, for example, cleaners or security guards. His question is, does the rule of no work, no pay apply to daily paid workers?
If it is daily wage pay, this is arguable. If no work, no pay, they didn't come to work because of the, it depends on if they cannot come to work or they're afraid to work. If you open during the COVID-19, if the business is not closed by the government order, you still open. Then the daily wage employee has to come to work. If they didn't come, you didn't have to pay. So the rules, no work, no pay, still apply. But if they didn't come to work because they're afraid of COVID, they cannot say that because the business still open. Okay.
Okay.
Yeah.
Next question from Kent Wiley. It's a short question. Are the labour courts still open at the present time?
The courts. Yeah.
Yes.
The courts still opened, but most of them send the summon. Yesterday, I got a summon from South Bangkok Civil Court to postpone the case to September. So most of the court postpone the case 1 or 2 months more.
Okay.
Yeah.
Next question, Valentin Waldman. In a case of relocation of a business, does the employer still need to pay the employee compensation for relocation? For example, concerning housing or annual plane tickets. So it's in the case of relocation of business.
Yeah, good questions. It depends on the employment contract. So if you put the clause that the employer is entitled to relocate employer to work another location, it's up to the employer discretion. If you have this clause in the contract, you can do. But if you have this clause, then the employer should have the clause that if it is a bargaining power of the contract, the employee should negotiate to put the clause in the employment contract that if another location is far away from Bangkok, and then they should have housing allowance or rental allowance, something like that. So up to negotiation. If there is no mention in the contract, no need to pay.
Okay. Next question from Kent Wiley, not really about employment, but he's asking about third wave assistance. And his question is, what about direct impacts on suppliers who are forced to close down when hotels close? Can they apply for assistance under the third wave rules?
The supplier, do they have the contract with the hotel to supply?
Yes, so the question is, it's not really employment, it's contractual entitlement. And can the suppliers apply for assistance under the third wave rules?
If there is not the continue, if there is not a continued contract or period contract on a case by case, so they cannot claim. But if there is a continual contract, you have to see whether the contract can enforce or not. It depends on the wording of the contract. For example, if you say that you supply to the hotel for 1 year. For example, vegetable. For this portion to the hotel 10 months or 12 months, and then you supply. The hotel said that, oh, the hotel is closed now. They don't want to get any supply, so do not accept. You can sue. The hotel is in breach of the contract.
Okay.
So up to the contract, it depends on the contract.
Okay, question from Kunnapaporn. This is a case where there is a contract that provides for 3 months' notice. Her question is, can the employer force the employee to pay money to the company if the employee resigns before? I assume the question is, the employee gives only 1 month's notice, but the contract says the employee is obligated to give 3 months' notice.
Yep, good question. The resignation, this is about the resignation. If you have a contract that either party can terminate the contract by giving another party 3 months period notice, but the other party resign or terminate the contract with only 1 month notice, so you can claim the others 2 months from the other parties. They are in breach of this contract.
Okay. Next question concerns sexual harassment. In a case of sexual harassment, can the employee be summarily dismissed without any severance pay, or is sexual harassment subject to a warning procedure, a warning provision?
Yeah, good questions. It depends on what it depends on what actually it is. It happened. For example, sexual harassment, if they just say something rude, say something which is about sexual harassment, they cannot claim anything. But if they do something more than that, they touch the body, they do other things which can be interpreted as committing criminal offense. For example, the offense of like you kiss her, you touch the body, which is a criminal offense, then it is subject to section 119 subclause 1. You know, commit, if you remember section 119 clause 1, committing offense against employer, committing offense against employer. If it is the commission of criminal offense, then you can terminate. But if it is not committing any offense, criminal action against employer, then maybe you cannot terminate on sexual harassment. It depends on how serious it is. Depends.
Okay.
You have to consider case by case.
This is the questioner who asked about the rules concerning daily paid employees. If a daily paid employee is willing and ready to go to work, but the employer has no work to give to that person, is the employer still liable to pay wages?
Yes. Yes. If they are daily wages and there are several Supreme Court precedents which rule that daily wage employees is ready to work, but employer has not work for them to do. The employer is in default of the contract. The employer has to be liable to pay wages anyway, because the contract still exists.
Okay. Next question concerns contacting the Social Security Office. The question is, does the employer have to contact the Social Security Office regarding claiming compensation of 3,000 baht per each employee?
Yes, they have to apply. Otherwise, they won't know. Have to apply.
Okay, good. Short
Yep.
answer.
Yes.
Next question. We're getting a lot of questions now.
Yeah.
If there's a contract with the employee that is separate from the salary and fixed allowance, if such an employee is dismissed, does the employer pay it compensation based on the salary? What about entitlement under the other agreement?
Can you
split salary? It's a question about entitlement if there are two contracts that the employee has.
There are two contracts. Sorry, I cannot catch up the main.
Yeah,
question.
There's two contracts. There's a contract of employment, but there's also another contract. They're entitled to a fixed allowance under the other contract. So is it a question of, it's a question of entitlement in a dismissal situation? Can the employee claim entitlements under both contracts? If it's for wages, can they claim compensation if it's for benefits or allowances payable under another contract?
I'm not sure I understand the question.
I think that's placed. Perhaps if Kun Aranchai can come back to our speaker afterwards.
I understand the content.
Okay.
I understand the question.
Let's come back to he can ask afterwards.
Yeah.
Question about company rules. If the company, if the work rules say that the employee who takes more than 2 days sick leave continuously, how is a weekend taken into account or holidays in between? So if the employee takes 2 days sick leave, for example, say a Friday and a Monday, how does that apply to the Saturday and Sunday in between?
Okay. Yeah. Section 119 subclause 5, absent from work for more than 3 consecutive days. Actually, the wording of the law says that even there is holidays in between, that means if you absent from work for on Thursday, Friday, and Monday, it is 3 days consecutively. Even there is Saturday and Sunday in between, it is already subject to clause 119, clause 1.
Okay.
Yep.
Kung Wasantachai is now being asked about annual vacation leave, where the employee applies for leave without pay for 6 months. Is the employee still entitled to annual vacation leave during the leave period, during the leave without pay period?
The leave without pay is a personal leave. Actually, the law has no specific rules on this. So it depends on the work rules. So the company can design your leave on personal leave. So
Okay.
you can amend your work rules to what as you wish.
Okay, next question is about tax payment in relation to severance pay. Who's responsible for paying the tax where severance pay is being paid? Which party?
The employees.
The employee.
Because they earn money. They have to pay tax to the government. They earn money.
Okay.
You can deduct.
All right, I think I'm going to have to make this the last question because we are overrunning. I'm sure it's possible if any inquirers would like to contact Kung Wasantachai separately after this event. The question is about employees in the red zone. Are they obliged to pay for their 14 days quarantine, or can they use their business holiday leave? What happens if they've used up that leave already? It's a difficult question. So it's a question of the 14-day quarantine period if you're an employee in the red zone, rather the dark red zone, I think.
Yeah.
Who pays for that quarantine in a hotel?
Yeah, that's a problem. Yeah, it's not definitely actually now because no measurement, no legislation under the Social Security Fund, the Social Security Office now, but the government just said that during the quarantine, the quarantine during the quarantine under the government order in the second wave, the government would pay. But now for the third wave, they didn't mention about quarantine 14 days by the government order. If you check this, no 14 quarantines for the third wave by the government order. So they won't pay anything now for the third wave.
Okay.
Yeah.
Well, we have rather overrun, so perhaps I'd like to draw the webinar to a conclusion. If any questioners would like to follow up with Kung Wasantachai afterwards, I'm sure he'll be very happy to help you. Yes. Can I say to our speaker, Kung Wasantachai, thank you very much for writing this event for us. The questions afterwards have ranged over a very wide range of topics, which shows the controversies that can arise under labour law under this COVID crisis. So can I express on behalf of everyone, and particularly the British Chamber, great thanks to Kung Wasantachai for presenting this event to us. And I'm sure he would be very happy to assist anyone who would like to follow up afterwards. So thank you very much, and thank you to all of those who participated in this event. Thank you.
Okay, thank you. I appreciate. Okay, thank you. Yeah.